is a man you've seen very many times here at Church of Uganda Family TV, ASP Asiimwe Muteera. You're most welcome. CLO Kawempe.
Good morning, Mr. Jumba.
It's a pleasure to have
that
you.
name is botanical. Good morning, our dear viewers. Like you always follow us. I'm Assistant Superintendent of Police, Asiimwe Muteera, the Community Liaison Officer Kawempe. I'm glad once again to be hosted here.
Okay.
I don't take it for granted.
Hey.
You know, the queue is very long. People who want to be here also to share, but once an opportunity comes for me, I always take it up.
Wow.
I don't disappoint.
Hey. That's very true. And so now today we're going to be talking about the tenants and the landlords out there. For starters, who exactly is a landlord? If we can first start by that, because there could be so many people masquerading as landlords. Who is a landlord?
A landlord in this category, or in this aspect of landlord tenancy, is any person who owns a particular property or is entrusted by the owner. For example, when I say entrusted by a owner, we have landlords who contact or who contract companies to collect the rent on their behalf.
Oh,
Yes.
those are landlords now?
Yes.
Okay.
We have agents of landlords. So in that particular time, once somebody has been empowered or has the authorization of the landlord, during that particular time, is a landlord.
Okay.
But
I thought the mandate entirely remains with the property owner.
the property owner, no. You have somebody who does not stay here but owns properties. They are companies which are responsible who contact such people, and it is just like in another law setup where you find that maybe you cannot be available but you can be represented under the law by somebody. So even in tenancy, somebody can represent you as long as you have given them the mandate.
Okay. Very interesting. So briefly, if you can also share light about what the law says about the relationship of a tenant and the landlord.
The law is, people are still locked up in the previous laws which existed. We have a new law that guides or regulates the tenancy or the relationship between a landlord and the tenant. And there are some key features which the landlord or the tenant must adhere to. Under that law, it was it is 2022.
Okay.
It is recent.
Oh, it's very new.
Yes. And it modified that relationship. But some of the key features: one, once a tenant and the landlord have to deal together or to stay together, or they are now into a relationship, because there is that relationship that binds them. It means that you, the landlord, you are offering your premises, but the tenant has a consideration to pay
Yes.
for utilizing your premises.
Mm.
So what does that mean? It means that there is something which is joining you together.
Mm.
Now, in this law, a tenancy can be either written, it can be implied, it can be by word of mouth, it can be a combination of any of the two. What do you mean by implied? Somebody can say that. What do you mean by implied? By the fact that now I am here, even if we have nothing written, I am your guest.
Yeah, true.
We don't need to write anywhere that what was he doing here. By the fact that I'm here, you have hosted me. It is implied that whoever comes and checks on us, it is implied that I'm your what?
Guest.
I am your guest.
Sure.
So similarly, by the fact that somebody has been giving you money, by the fact that somebody is utilizing your premises, it is implied that he is your tenant. So some of those clauses in the clauses in the law may bind both of you. You cannot say that I even don't know you. Where did we write? But you have been receiving my money. You have been receiving it as who? Have I been loaning you? So it is implied that by the fact that you have been receiving my money, even if you have not been giving me a receipt, it means I have been your tenant. So two, the law guides on how each one should conduct themselves during that period. The do's and don'ts.
Yeah.
For either the landlord and the tenant. For example, as a tenant, it is your responsibility to pay rent.
Rent, yeah.
You have no excuse for not paying rent, whether you are working or you are not working.
As long as you're paying.
Whether you are sick or maybe you had problems. you cannot use that, but don't you see I'm no longer working?
That's not an excuse.
Two, as a landlord, you also must, once somebody is utilizing your premises, is entitled to enjoyment of their tenants. You're not supposed to be infringing on them every time and again. You tenant, somebody must have that quiet enjoyment as they are in your premises. As a tenant, it is your responsibility to pay for your utilities, unless it is stipulated in the tenancy agreement that the money you are paying includes utilities such as water and electricity. But if it is not included, then you pay for your utilities. You know, we have tenants, they accumulate bills, then they disappear at night. But also, as a landlord, it is your responsibility to ensure that your premises are habitable. You know, there are landlords who only think of money. You find the structures are dilapidated, the roof is leaking, what. But at the end of the month, wants money. So if the landlord says, the tenant says that, but the roof is leaking, we are saying, no, that for you pay. If you are not interested, leave my house. Your house or your premises should be in a habitable manner, so that you don't infringe on the rights of the tenant. You know, when it is inhabitable, the tenant is prone to diseases. That weather, somebody is exposed to cold weather, and they may develop some diseases. Like I said, that this tenancy agreement can be in writing, it can be by word of mouth. I want your house, how much, pay this, you will be doing like this, you can be doing like this. Okay. It can be both writing and by word of mouth. It is also acceptable. It can also be in form of data message. Somebody is on WhatsApp say, I need a house.
I need a house.
The house is there. You pay. You are typing. Just typing, exchange of messages. You are entering into a what? An agreement. Then, like I said, it can be implied. The acts. The acts. It is implied. So, like I said, you know, here in this law, payment is in Ugandan shillings. But there are some landlords and their tenants who sit and agree that for us we shall pay in another currency. I know some time back we had issues with our traders, especially here in town.
In dollars.
They were complaining that landlords want money in what?
In dollars.
In dollars. But the law talks about our Ugandan shillings. But through modalities, I don't know how it was resolved. But since we are in Uganda, it's Ugandan shillings. Then it also mandates the landlord that if it is a tenancy, there is a tenancy agreement. The tenant also should give the landlord should give the tenant the copy of that law, so to know. What is here? Sometimes landlords and tenants can sit and formulate new modalities, but the law says that what is prescribed in your tenancy should not contravene with what is existing in the law. For example, the law talks about that once a landlord wants to repossess their premises, a monthly tenant should be given not less than 30 days. Notice of termination. However, the landlord can give you more than that, or you can agree to a period which is more than 30 days.
Not less.
No, if it becomes less, it becomes void. It does not hold water. It cannot be enforced by the law. But it can be more than that. So, something which makes the law better is acceptable.
But how about the tenants themselves? Because sometimes they also want to terminate and go somewhere else. Is it the same? Like they should also give the landlord some time, or they just
the law did not talk about that, but there are some landlords during in their tenancy agreements, they stipulate it. That if you are a tenant, you want to go, also notify me in advance. Why? They know there is a period, that's time lag, where the house is vacant, so they are losing out. So when you say that at the end of this month I'm leaving, then the landlord puts the house on the market. 2, there are tenants who pay security fee, or there are landlords who collect security fees. So once you notify them, it enables them to mobilize for that security fee. However, the current analysis shows that the landlords are finding it hard to refund security fees. They will look for all avenues to either reduce or not to refund that money. Somebody will look at the wall. They don't know that even there is that time for depreciation. You know that even once you this structure, even if it is not being utilized, it automatically depreciates.
True.
But landlords are finding it very hard to release that money.
They'll get any excuse.
Fault finding. During my high school, we were paying a certain fee called caution money. Now that caution money, it was like a security in this matter. So whenever you could finish your level of education, maybe senior 4, senior 6, you have cleared all. You would clear with the quartermaster, you clear with the kitchen, you clear with the store, you clear with the library, you clear with the dorm master, very many things in order to qualify for that money. So whenever you were faulted somewhere, it would be a time for the librarian who would check, say that you took this book, you did not what?
And they choke.
And you may find even that money was even less than what even some of the items you could be required to produce. So, but it was a requirement, and we all ensured that at the end of you have your caution money. It was very little. I think by last time they were giving us 5,000, but it was too much, and we could struggle to clear.
Get it.
To get that money. So, but landlords, you are finding it hard to refund security money. I don't know why. Like I said, the house should be suitable for human habitation. You know, some structures are dilapidated. So it is your responsibility as a landlord to ensure that such fees, such when somebody is paying money, there should be value for money. I know some attach a fee to the services you're supposed to get. That if the structures are dilapidated, they are not in a habitable condition, you pay little money. That is the most important. What is most important? Are you under a roof? You find there are houses which even go up for 20,000.
20?
Yes.
Where?
In Kawempe, where I come from.
How was that?
It's way there. Houses
and someone
there.
sleeps.
Yes, they are makeshift. What made of timber and the iron sheets, and you can be there. You close. You are in your own house.
Wow.
Yes, and it is, and people are collecting rent. Others are doing their businesses. The law also talks about on repairs.
That's what I wanted to ask.
It is a responsibility of the landlord to repair,
not the tenant.
but there are also provisions. There are certain instances where there is an urgent need for repair. But for you, the landlord, to do it, you must notify the tenant to do it. You must notify
the
landlord that there is this and this, so that he or she okays you. But in instances or circumstances where you are not able to get in touch with the landlord, and the repair needs a very urgency, you can do it and inform thereafter.
Okay.
But you are also supposed to ensure that you have operated within the modest means. Don't exaggerate, because you have done, then you want to exaggerate.
But will they accept, or you have to have evidence?
Yes, of course, everything is evidence based. There must be receipts.
Some landlord will complain that it's you in there. Maybe it's you who has spoiled things.
It depends. That's why there is always that room for arbitration. And there are stipulates circumstances where the tenant may make repairs. One, you say maybe the water pipe has busted. That one, the water bill is accumulating.
Yeah.
Maybe the water is going to spoil house properties. Two, broken sewage, especially in the toilet. Roof leaks. Maybe there was a storm and maybe the roof was taken. It is very urgent intervention. You cannot say that now you wait, I will be coming. you repair.
Yeah.
Gas leaks. You know, there are some premises which people have already fixed those gas pipes and what. So if it leaks, it is an emergency. You cannot wait. It has to be worked on there and there. Electrical faults. Anything to deal with a fault, it endangers the life of the habitants. Storm or fire damage. So those are when you hear about them, you see that it is emergency. It does not wait for tomorrow. It is either today or today. There is no room for tomorrow. But like I said, it must be within the modest means. Don't exaggerate bills because they have told you that now you have a provision where you can do it. Then you say that now I used a lot of money, almost the whole money for the month to repair this. No, it should be
Modest.
average. The law also talks about on the usage of the premises. As a tenant, you are supposed to use the landlord's premises for lawful purposes. You know any unlawful purpose?
I remember, was it some time back when people were in a house having bombs or whatsoever?
Very good. The house should be for lawful purposes. You should not rent a house for an illegality. So once the landlord believes that you are using their house for unlawful purposes, they can evict you. But also we require them to report, not just evicting you, but they should
report.
They should report. As a tenant, you are required to keep the premises the way you found them.
Okay.
This normally happens to tenants with families. You find you have children, they spoil everything. They write over the walls. They use nails to write on the walls. They do very many things. So at the end of the day, you find the house needs serious repairs.
By the way, I've seen that very common, whereby someone goes to a house and they want it, but then the landlord tells them, first pay the money, then we renovate it.
Yeah, that means that the tenant who previously occupied it did not keep it the way they found them.
So it is the mandate of the tenant to leave the house the way you found it.
Yes. Of course, there are usual wear and tear. There is that, like I told you, once even this room is not being used,
yeah.
Automatically you may find some of the paintings they are dirty. Maybe you find some walls they are peeling off. So there are certain things which are automatic or which are natural that they will happen, but there are those which are man-made, like somebody writing on the wall either with a pencil or with a nail, like these children normally do.
Okay.
Like breaking it, taps. Somebody is breaking the sewage line, dropping in the sewage line things which are not supposed to be dropped in there.
Okay.
So automatically that one, the tenants are always cautioned about such.
All right.
And if there is any blockage, I said it is at your cost. If something happens as a result of your actions as a tenant,
it is at your cost.
The cost of repair is entirely on you.
Oh.
Yes.
Okay. Very interesting. I believe let us first take a short break and we shall return with more of this. Please stay on. The landlords and tenants, you want to have this information into yourselves.
Issues at hand. This is Church of Uganda Family TV, enriching lives. regulated by the Uganda Communications Commission. This is Church of Uganda Family TV. Enriching lives. Regulated by the Uganda Communications Commission. Issues at hand. Issues at hand.
All right, welcome back. We are speaking about what you as a tenant or you as a landlord should know in regards to this relationship that you build immediately when you two meet, the landlord and the tenant. We have talked about a number of issues, and ASP Muteera here is taking us through these important issues that you should know, important aspects you should know as a tenant or as a landlord. And yes, we did talk about a number of them. So I find there are always a number of issues. We always find the relationship is not usually so smooth between these two parties, and there are so many disputes that keep arising. So, and when you were talking about the agreements, apart from the documented one, can the law defend a verbal agreement or something we are texting and we agreed to have in? Because at the end of the day, when issues arise, you have to provide proof. So if any issue has happened, or maybe someone is denying they did not pay the money, or someone is saying I paid the money, anything of that sort, what agreement are the tenants supposed to have, or the landlords?
Well, something which is in text can as well be put on record.
Okay.
We have seen people send messages, then after a short while, they delete.
Exactly.
Others put in that disappearance. The message disappears for
20.
but there also we have text messages, not only WhatsApp messages. We have text messages.
SMS.
Once somebody has sent you a text message, they cannot delete it. So it will be in your what?
Phone.
To be in your phone. Even while agreements which are by word of mouth, they can also. We have had most contracts. They are verbal. It is verbal, and you can prove. But verbal goes hand in hand with implied. Whereas we spoke this, but we also did this.
Okay.
So they support each other. They work hand in hand. In this modern era, we try as much as we can to sensitize members of the public that let there be something written, because you don't know tomorrow. A written agreement helps both of you.
Yes.
You know, a landlord think that by not giving tenants written tenancy agreement, that it is to their advantage, but somehow it has turned to be to their disadvantage. There are those tenants who are errant, and somebody will be in your house for even a year and not giving you money. Somebody will say, I gave you money. So for a cordial relationship, for a harmonious relationship, at least put something written. Even when they put it in writing, they do. You cannot write it all. You cannot. Even this book did not bring out everything, but it created a provision that where differences arise or where misunderstandings arise, they shall seek redress from courts of law.
Yeah.
Because this law does not work in isolation. It is supported by other laws. So, but you can put in the tenancy agreement the basics. How much do you pay? Now, like in payment, there are landlords who increase rent every month.
Every month, yeah. True.
Every month they are increasing, and it is illegal.
Yeah, it is illegal.
To increase every month the tenant rent, it is illegal. And even increasing rent, you do not wake up and say that tomorrow
we are paying this.
You are paying this.
Hey.
The law talks about you give a 60 days notice. Now we are in October. Somebody who wants to increase rent now, you landlord who is watching us, if you want to increase rent, this is the time now to write to your tenants. And that means that it will take effect next year in January.
Okay.
60 days. So once, but you also have a tenancy which is fixed. Fixed tenancy, there are tenants who they have a fixed period of time. Maybe 6 months, 1 year, 5 years. This one does not apply to them. Okay. Somebody who has a fixed tenancy, you cannot increase rent. You can only increase at the end of their fixed term.
Wow.
So during this period, once you write to the tenant that I'm increasing rent, the tenant should either reply or say that this is too much or I am unable. Then you say that, okay, if you cannot manage this, pay this. Or if you cannot manage, then look for where to go. But if a tenant keeps quiet, it is implied that they have accepted. At the end of the period, you cannot say that, but the landlord, really, can't you see me? Even I have been struggling to pay this. Then you have been, for you, can't you be human enough? But you kept quiet. The time is not favorable for you. It is too late. And like I said, you cannot increase rent in a period of less than a year. There are those who increase after every. They keep on increasing. It is illegal. It also gives provision. If you have to increase, how much? Now here landlords are going to cry. You are not supposed to increase more than 10% of what the tenant has been paying.
Okay.
But others, we have seen the increase even 100%.
100%, yeah.
You have been paying 500, then say that now my premises are at 1 million. Because, you know, tenants keep on, you know, you are aware that tenants are the ones who give premises value.
Oh.
You find some places are dull. But once certain tenants rent there, then the price peaks. You know, we have this common vocabulary that the price has started peaking. So once the price is peaking, and maybe the business around has started booming, now landlord say, now this is the time
to increase
the rent. So don't increase more than 10%.
Okay.
And
in what period of time is that?
In 1 year.
Hey.
Yes.
Oh, wow.
In 1 year. And whoever increases rent but has not followed these guidelines, it contravenes the law. So the tenant can challenge that. But of course, you know, now landlords are getting more wiser. If they want to increase rent, they don't increase with the current existing tenants. They find a means of letting you go, so that somebody who is coming will say that my house is at 500.
True.
So you either enter or
leave.
But once for you, as the landlord said that you have been paying 300, now I need 500. You are going to complain the whole day. So landlords are avoiding that. So they fix with new tenants. You are entering, you enter on a new rate.
Okay.
That's what they are using to manage the situation. Because our people don't, when it's all about of increasing in everything, but as long as it is related to money, you know there will always be such complaints.
Yeah. Okay. So when do you come in as police to help in these issues?
The law talks about on termination, and we have section 29 on tenants who have failed to pay rent. The law talks about that where the tenant has defaulted to pay rent and it is in arrears, it says that the landlord may apply in a court of competent jurisdiction to recover the rent owed. Somebody is in your house 1 month, 2 months, 3, 4, 5, and you don't see any signs of recovering rent arrears. You may go to apply. Clause section, that was section 29, subsection 1. Subsection 2, that where the default in subsection 1 continues for a period of more than 30 days. The landlord shall be entitled to re-enter their premises and take possession in the presence of the local council official and the police.
Okay.
Somebody is in your house, doesn't want to pay, doesn't want to leave. So it is so or put a provision for a landlord
To evict you.
to gain access to their premises by the help of.
Local council.
But this is not a black check. No. You also have to follow certain modalities.
Hey.
Yes, because once the law says that if you repossess your house when you have faulted anywhere, the tenant may also run to court to seek redress. And some of the redresses say that you will, what the landlord, the tenant is entitled is you, the landlord, compensating him an equivalent of 2 months on top of what other punishments that the presiding magistrate may prefer.
Okay.
So it is not everywhere that you will repossess. There must be certain grounds. Maybe there is no communication. Maybe there is you are hostile to the landlord. You know, there are tenants who become hostile. They don't even want to see the landlord near their premises. Somebody takes as if now they have owned. But there is such provision for that. Like I told you on security deposit, security, there is also provision. It shouldn't be more than even what the person is paying. In most cases now, the landlords require an equivalent of 1 month, but in form of cash. But landlords refunding that money, I don't know, you are finding it very hard. I know landlords are watching me. You are finding it hard to refund.
Okay.
You look for all avenues.
So how about there's this issue of locking someone out or confiscating their property? It is majorly done by landlords.
Doing what?
Locking the tenants out and also confiscating property.
That is illegal. You are not supposed to lock the premises, because once you have any matter, you are supposed to run to court. You don't lock, because when you lock, what do you get? Okay, let's be in normal circumstances. Yes, you are demanding me and you lock the house. Do you get the money?
No.
So what is the essence of locking? Locking is to inconvenience. But you can inconvenience somebody and they don't feel inconvenience. Say you lock somebody, ignores you, and they go. Then you are not utilizing the house, neither the tenant utilizing it. However, there are tenants who lock the houses and disappear.
Oh.
They also there.
They leave their property in.
Others even don't leave properties.
Hey.
Others just lock and just they want to inconvenience you, the landlord. You think that they have their properties, but the properties are not there. So, technically, all the law says that if you have locked somebody's house for a period of 30 days, no communication, the landlord is unable to hear from you. Automatically, you have broken your tenancy. You have terminated your tenancy. So the landlord may seek redress to repossess their premises. So once you tenant, maybe you have others have long journeys, please notify the landlord so that they don't presume that you have automatically terminated your tenancy. Notify them so that they know that you are returning soon. But also not only informing them, but you also must you must pay.
Mm.
Because somebody might go for further studies for 1 year. But keeps on saying, landlord, I'm coming back. I still need that house. But the house is locked. Money is not paid. So really, that is an inconvenience.
Business. So finally, what message do you have for both parties, at least to promote peaceful coexistence?
I always tell, as the Department of Community Affairs, we always have, we engage in dispute resolution arising from misunderstanding between a landlord and a tenant. But one of the messages we always give, and that I also want to give our dear viewers, tenancy is a relationship. Once the relationship is sour, why don't you part ways? If you are renting somebody's premises, but you feel maybe they are always hostile, they are harsh, they overdemand, they are inconsiderate, why don't you leave their house? You say I am bad, but you don't want to leave me. You leave that bad person and look for move on. So once communication has been blocked, or there is unfavorable ground for communication, you can no longer speak one-on-one with your landlord. Matters begin at LOC, then they go at police, then they go to court. I think the alternative, and which is the best, why don't you part ways? Maybe for fixed term tenancy.
Okay.
That maybe you had rented these premises for a period of 5 years. Then the relationship deteriorates when you have about 2 or 3 years. That is understandable. But this one is monthly tenant. By annual tenants. You hold on at the end of your period, move in peace, other than pulling ropes with the owner of the property. But also you owners of properties, you landlords, certain things you can ignore. Ignore. And we prefer put in writing. This law provides for termination. That once the landlord feels that they want their premises, they write to you. I told you that. Yes. There are those tenants of weekly. These ones makeshift structures, weekly. Give the notice of 7 days. That's what the law says. Monthly, 30 days. These ones who pay more than like a year or what, 60 days notice. They don't quarrel. You just put in writing. And they did not give them that terminate if you have this reason. No, as the landlord has no reason, may not even state the reason as to why they want their premises. That you say that this reason is valid or it is invalid. No. As long as they feel you cannot stay together, they should write to you. Others put their provisions, and maybe I want to renovate my house or what. Others go on ahead and state why they are chasing you. Say you are indisciplined, or you don't want to pay, or you have faulted the, and those ones where you have written tenancy agreement, you can even quote a specific that you are having breached rule number 13 of your tenancy. I therefore notify that at the end of these 30 days, I need my house. So you know that yes, it is true what they have quoted. I have been breaking, or I broke this rule.
Okay. Wow. Thank you.
But we believe that there must be a cordial relationship. That guides the landlord and the tenant.
Okay. Our time is spent. If you can give us just 30 seconds parting shots.
One is to thank the management of Family TV for always considering security, and you have clearly earmarked this period for us. We don't take it for granted.
Yeah.
Other media houses should copy and paste.
Okay.
And to the general public, always reach out to us in case you have any challenges in all aspects of life, so that you get immediate solution. You know, some things can be manageable at their initial stages, but because we take long to report, situations escalate and you find maybe they are beyond our control. So always report in time for quicker and immediate solutions.
Okay.
Thank you very much.
Thank you so much. ASP Asiimwe Muteera is the community liaison officer for Kawempe, and he has been here a number of times, and every time we have him, we always get very important information. I hope you landlords and tenants have gotten important information to know during that relationship that you have together. And of course, the biggest part of it is making sure that you coexist peacefully. I want to appreciate you for joining us this morning. My name is Luke Majumba. Please have a lovely day.
Issues at hand. This is Church of Uganda Family TV.